All right, we've got this breaking news just coming into our newsroom right now.
If a police officer asks you about drinking, drugs, or guns, your answer could be the difference between going home or going to jail.
This is something that actually comes from common law England. The king is sovereign, and the government has to waive that sovereign immunity.
That seems like guilty until proven innocent. That's not within the lawful jurisdiction of a government.
Even if you are innocent, your words can still be twisted and taken out of context.
3 words destroyed a Texas man's life. He had no criminal record, carried legally for 15 years, and thought he was doing everything right. Those 3 words, yes, I have. Now he's out $14,000, spent 2 years fighting felony charges, and lost his concealed carry permit forever. The officer asked one simple question during a routine traffic stop. The answer seemed obvious, honest, straightforward, but those 3 words triggered a legal avalanche that crushed an innocent gun owner. This happens every single day across America. Licensed carriers, responsible gun owners, people just like you, watching their lives implode because they said the wrong thing at the wrong time. What you're about to discover will fundamentally change how you handle every police encounter for the rest of your life. Because the most dangerous moment isn't when you're breaking the law, it's when you think you're following it. The legal system has a dirty secret that prosecutors don't want you to know. There's a doctrine buried deep in criminal law that turns your honesty into handcuffs. It's called admission against interest, and it's the nuclear weapon prosecutors use against law-abiding gun owners. This isn't some conspiracy theory or sovereign citizen nonsense. This is established legal precedent that convicts licensed carriers using their own words as the primary evidence. When an officer asks if you have a weapon and you say yes, something profound happens in the legal universe. You've just created what lawyers call an admission against interest. This means you've voluntarily stated something that could potentially harm your legal position. The critical part that destroys lives is that this admission becomes evidence immediately. Not after you're arrested, not after Miranda rights, not after you're charged. The second those words leave your mouth, they're locked in as potential evidence. Here's where it gets terrifying. The National Association of Criminal Defense Lawyers analyzed weapons cases from 2023. They found that 73% of prosecutions against licensed carriers relied primarily on the defendant's own roadside admission. These weren't criminals caught red-handed. These were permit holders who thought cooperation meant compliance. The admission against interest doctrine doesn't care about your intent. It doesn't matter that you were trying to be helpful, honest, or safe. The law only cares that you confirmed possession. Once you've done that, prosecutors just need to find any technical violation to hang charges on. Maybe your permit expired last week. Maybe you crossed into a jurisdiction with different laws. Maybe there's a school zone you didn't know about. The admission gives them the foundation to build a case. Michigan statistics paint a disturbing picture. 412 licensed carriers faced weapons charges in 2023, where their roadside admission was the primary evidence. These people had permits, had training, had clean records. But they all made the same mistake. They answered a simple question with simple honesty. The body camera revolution has made this exponentially more dangerous. Every officer wears a high-definition recording device that captures your exact words, your tone, your hesitation. 6 months later, when a prosecutor reviews the case, they're not reading a report. They're watching you in living color, making statements that become the cornerstone of their prosecution. But confirming you have a gun is just the beginning of the trap. What happens next is even more legally devastating. Because after you admit possession, the officer asks a follow-up question that seems perfectly reasonable. Where is it? This is where good people trying to be helpful accidentally build the prosecutor's entire case. When you tell an officer your gun is in the glove box, center console, or under the seat, you're not just providing information. You're establishing what courts call immediate access and constructive possession. These aren't just fancy legal terms. They're the difference between a warning and a felony conviction. The Firearms Policy Coalition tracked this phenomenon in 2023. They found that location-specific statements contributed to convictions in 64% of improper storage cases nationwide. Think about that. Nearly 2/3 of storage law convictions happened because the defendant voluntarily explained where their gun was located. Here's why this matters. Storage laws change dramatically between jurisdictions. What's legal in your driveway might be a felony 3 miles down the road. Most gun owners know their home state laws, but what about the state you're driving through, the city you're visiting, the county you just entered? Illinois requires unloaded firearms in enclosed cases without a carry permit. New York demands locked containers with ammunition stored separately. New Jersey might as well be another planet, requiring trunk storage unloaded while traveling directly to specific authorized locations only. Cross any of these invisible legal boundaries with your gun stored wrong, and you're committing a crime. Tell the officer where it is, and you've just proven you committed that crime knowingly and deliberately. A Pennsylvania man learned this the hard way in 2023. Valid Pennsylvania carry permit, zero criminal history, driving through New Jersey to visit family. State trooper pulls him over for speeding. He volunteers that his unloaded handgun is in the center console, trying to be transparent and safe. 8 words, that's all it took. New Jersey doesn't recognize Pennsylvania permits. His description proved knowing possession in an unauthorized location, felony charges, 18 months of legal battles, $23,000 in attorney fees. The prosecutor's entire case consisted of those 8 volunteered words. Courts have consistently ruled that voluntary disclosure of location demonstrates consciousness of possession. In plain English, telling them where it is proves you put it there on purpose. You can't later claim you forgot about it, didn't know it was there, or someone else put it there. You've eliminated every defensive argument your attorney could make. Now let's talk about the permit verification trap that catches even the most diligent gun owners. You're pulled over, you've admitted you have a gun, told them where it is, and now you want to establish that you're one of the good guys. So you say those fatal words, "I have my permit." Sounds like you're asserting your legal right to carry. In reality, you've just made a factual claim that triggers mandatory verification. The Armed Attorneys Legal Group studied this in 2024. They found something shocking. 28% of permit holders who claimed valid permits during traffic stops discovered administrative issues they had no idea existed. Expired permits because renewal notices went to old addresses, suspensions triggered by unpaid tickets in different counties, reciprocity failures from crossing state lines, address change requirements they never knew about. Wisconsin, January 2024, a permit holder tells an officer he has a valid concealed carry permit, seems reasonable, he's had it for years, pays his fees, follows the law. The officer runs it, expired 11 days ago. Wisconsin requires renewal 90 days before expiration, but the notice went to his previous address. Now he faces 2 charges: carrying concealed without a valid license and making a false statement to law enforcement. The second charge carries harsher penalties than the first. Think about that. If he'd simply remained silent, he'd face 1 charge. By trying to establish his legitimacy, he doubled his legal jeopardy. His attorney later explained that invoking the right to verify status through counsel would have prevented the false statement charge entirely. But how many gun owners know to do that in the moment? Even when your permit is completely valid, the verification process creates new dangers. Officers now have legal justification to extend the traffic stop, run extensive database checks, look for any flags or warnings. What started as a simple speeding stop becomes a comprehensive investigation into your firearm status. The intent escalation trap is where misdemeanors transform into felonies with just a few words. An officer asks why you're carrying, you give the obvious answer: for protection, for self-defense, because it's my right. Congratulations, you've just handed prosecutors proof of mens rea, guilty mind, the deliberate intent that upgrades charges and activates sentencing enhancements. The Cato Institute found that intent statements increased average sentencing by 340% in weapons cases, ending in conviction. That's not a typo. Your explanation of why you carry can more than triple your sentence. Here's how it works. Possessing a firearm in a prohibited location might be a simple misdemeanor. $1,000 fine may be probation, but possessing a firearm in a prohibited location for the stated purpose of self-defense becomes evidence of willful violation. You knew the law and chose to break it because you prioritized personal protection over legal compliance. Oregon, 2024. A concealed carry holder enters a courthouse forgetting it's a prohibited location. Security finds his gun. He could have stayed silent. Instead, he explains he always carries for protection and simply forgot about the gun-free zone. That statement transformed a violation into a felony with a 3-year minimum sentence. His intent to carry for protection proved deliberate action, eliminating any good faith defense his attorney could argue. The panic statement paradox might be the cruelest trap of all. An officer unexpectedly discovers your firearm. Your brain floods with stress hormones. Your mouth opens before your brain engages. I forgot it was there. I wasn't going to use it. I haven't touched it in weeks. Every one of these panicked explanations systematically destroys your legal defense. When you say you forgot it was there, you've admitted knowing possession. You can't forget something you never knew existed. This eliminates arguments about unawareness, someone else placing it there, or lack of knowledge. In states with negligent storage laws, forgetting is literally confessing to the crime itself. When you claim you weren't going to use it, you've confirmed you knew it was present and accessible. This destroys Fourth Amendment challenges to the search that found it. If you didn't know about the gun, the search might be questionable, but you've just validated the search by confirming what they found. Adding that you haven't touched it recently invites forensic analysis. When your fingerprints appear on the grip, magazine, and slide, because of course they do, it's your gun, you've now made a provably false statement. That's a separate criminal charge in most jurisdictions. North Carolina 2024. A gun owner tells officers he completely forgot about the gun in his trunk from last month's range trip, swears he hasn't touched it since. His prints were everywhere. The false statement charge carried a harsher sentence than the original weapon violation. Here's the Miranda misconception that traps countless gun owners. You believe you're protected because they haven't read you your rights. This fundamental misunderstanding of constitutional law destroys lives every year. Miranda warnings are only required during custodial interrogation. A traffic stop is a detention, not custody. Courts have consistently ruled this distinction matters. The FBI's uniform crime reporting data from 2023 shows 89% of incriminating statements in weapons cases were made during non-custodial encounters where Miranda didn't apply. Officers are specifically trained to gather information during the detention phase because every word is admissible without warnings. California Appellate Court 2024, a driver makes detailed admissions about his firearm during a traffic stop. At trial, his attorney moves to suppress the statements because Miranda warnings weren't given. Motion denied. The court's ruling was crystal clear. Miranda protections don't apply to voluntary statements made during lawful traffic stops prior to arrest. The defendant was free to invoke his right to silence but chose to answer questions. The duty to inform minefield adds another layer of complexity. 18 states require you to notify officers you're carrying during traffic stops. Sounds simple enough, just tell them you have a gun, but the exact wording requirements vary dramatically, and incorrect phrasing turns legal notification into self-incrimination. Ohio requires prompt notification, but the statute doesn't specify exact language. Toledo, 2024. A carrier says, "I've got a weapon." The officer interprets this as threatening language, charges him with failing to properly notify, and inducing panic. $7,400 in legal fees before dismissal. North Carolina requires you to disclose both that you have a permit and that you're carrying. Charlotte carrier says, "I'm carrying," without mentioning his permit. Citation for improper notification because the law requires both elements. Louisiana demands immediate disclosure. Baton Rouge carrier waits until the officer asks about weapons. The delay violated immediate notification requirements. Citation stands. The U.S. Concealed Carry Association identified 147 different notification scenarios across duty to inform states. The requirements change based on traffic stop type, officer approach, passenger status, vehicle location. It's a legal minefield where one wrong word triggers violations. The recording reality of modern policing has fundamentally changed the game. Body cameras, dash cameras, and AI-powered analysis systems capture everything. The Police Executive Research Forum found that body camera footage is now primary evidence in 68% of weapons prosecutions, surpassing physical evidence and witness testimony. These cameras capture more than words. They record tone, body language, nervousness, hesitation. Prosecutors play these recordings for juries, arguing that your shaky voice proves consciousness of guilt. Your quick clarification shows attempted cover-up. Your pause before answering demonstrates deception. AI systems like TrueLeo, deployed in over 400 departments, use natural language processing to identify admissions, contradictions, and legally significant phrases. These are automatically flagged, transcribed, and embedded in reports before the officer returns to the station. Minnesota, 2024. True. Leo processes a traffic stop, automatically flagging, "It's in my console," and generating a report summary stating, "Subject admitted to knowing possession of firearm in vehicle center console." The AI built the prosecution's case before the driver even left the scene. The attorney invocation advantage represents your only reliable protection. The most powerful phrase in American criminal law is, "I'm invoking my right to remain silent and I want to speak with my attorney." This triggers multiple constitutional protections simultaneously. First, it invokes your Fifth Amendment right against self-incrimination, legally prohibiting continued questioning. Second, it invokes your Sixth Amendment right to counsel, requiring all communication through your attorney. Third, it creates a clear record that you're not waiving any rights. The National Association of Criminal Defense Lawyers found that defendants who invoked counsel during initial police contact had case dismissal rates 440% higher than those who answered questions. Not because invoking rights makes you look innocent, but because it prevents you from providing evidence prosecutors need. When you request an attorney, officers must stop investigative questioning. They can still ask for identification, conduct safety procedures, complete the traffic stop's original purpose, but interrogation about firearms must cease. Utah 2024. Gun owner invokes counsel during a stop. Officer continues questioning. Gun owner repeats, "I've invoked my right to counsel and won't answer questions without my attorney present." 7 repetitions during the stop. All subsequent statements suppressed at trial. Every year, thousands of legal gun owners lose their permits, pay crushing legal fees, face criminal convictions, not because they broke the law, but because they said the wrong thing during a traffic stop. The difference between freedom and prosecution is knowing when to stay silent. Your words can and will be used against you, even when you think you're being helpful, especially when you think you're being helpful. The next time you're pulled over, remember the Texas man who lost everything with 3 words. Remember the Pennsylvania driver whose honesty cost him $23,000. Remember that your rights include the right to remain silent, and sometimes that's the most important right of all. That's it for today, folks. See you in the next video.